Court will find you guilty. Court will sentence you to 3 years in the prison, give you credit for any time served. All right, this is for sentencing, correct?
It is, Your Honor. Yes, yes, sir.
All right, who's the prosecutor on Anette Idago?
Yes, you guys.
Is this criminal trial division?
Yes, Your Honor.
All right, Jason, are you on this?
Yes.
Okay. Everyone, we're going to go on the record. So, counsel, if you can ask the deputies, they'll move you down there. You're welcome. And do not, as a reminder, do not approach the bench or the coordinator or the clerk when we're on the record. Court is calling 2023 CR 7274, State of Texas versus Anette.
Today's case is anything but ordinary. A mother of 5, Anette Idago, stands before the court, facing sentencing for aggravated assault with a deadly weapon. The charge? A violent confrontation allegedly caught on video, where prosecutors say she chased another woman with a knife. But Anette claims it was self-defense. She pleads for probation. Her lawyer leans hard into her lack of criminal history. But there's a twist. 2 versions of the same night, and a single video may change everything. Was it truly self-defense? Or a dangerous act of vengeance? Stick with us, because this courtroom gets tense, emotional, and brutally honest.
Anette Idago, can I have parties announced for the record for the state?
Jason Garrett, Your Honor.
Defense?
Good morning, Your Honor. Daniel De La Garza for the defendant.
And are you Anette Idago?
Yes, ma'am.
You entered a plea of guilty on November 16th. According to the plea bargain agreement, punishment is to be assessed at 9 years in the prison. There's an affirmative finding of deadly weapon, and the state is silent on your application for deferred adjudication. Have both parties had a chance to review the PSI report, state?
Yes, Your Honor, I'm reviewing it right now, but since you're silent, I'm fine with reviewing it and go on.
All right. Defense?
I have reviewed it, Your Honor, and showed the same to my client.
All right. Any objections to the PSI report? Defense?
No, Your Honor.
All right. All right. The state is silent. Defense, do you have any witnesses?
We don't have any witnesses, Your Honor. I would just like to point out that Ms. Idago's husband is in the courtroom.
Okay.
Her father is also in the courtroom. He's standing. She has a supportive family, that kind of stuff.
Okay.
I don't think the testimony is necessary. I can argue it, and it's in the PSI.
Okay.
But so we have no witnesses.
All right. Well, if you want to address with your client, because there's where it says guilt acknowledged, there's an X there, which I'm assuming guilt is acknowledged, but there is also an X that says guilt is minimized.
Now here's where legal nuance matters. Both sides have reviewed the PSI, Presentence Investigation Report, but the prosecution is silent, meaning they're not recommending a harsher or lighter sentence. That silence can be strategic. It puts full weight on the judge. And let's not overlook the affirmative finding of a deadly weapon. That detail alone eliminates eligibility for certain leniencies, like deferred adjudication, unless the judge makes an exception. The stakes? Extremely high. One wrong move in this moment could lock Annette's future behind bars.
I could ask you some questions, Judge.
Sure. Can you raise your right hand for me, please?
Yes, ma'am.
Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right. You can lower your hand if you'll state your name for the record, please.
Anette Garcia Idago.
All right. Make sure you keep your voice up so that the court reporter can hear. All right.
Okay.
All right. Defense.
Thank you, Your Honor. Okay, and you know you're here for sentencing today, right?
Yes.
And you pleaded guilty to aggravated assault with a deadly weapon,
Yes, sir.
right? Now, tell the judge at the time, and it's in the PSI, we talked about it, but tell the judge at the time that this was happening, what was going through your mind?
Self-defense, Your Honor. I was
And-
simply trying to defend myself. I'm sorry.
Okay, that's fine. And then now, since I've become your lawyer, you've looked at the evidence and all that kind of
Yes.
stuff. Have you realized now, do you know whether it was self-defense or not?
Yes.
And you think that it was not, or do you think it was
I
self-defense?
believe in my heart it was self-defense.
Now, do you take responsibility for what happened, though?
I do know now that it's, in my mind, in my heart, it's self-defense.
But you know now that it
But I
was,
know, yes, sir.
tell the judge that it was
I
what?
do know now.
All right. So I'm sorry if
Yeah,
you all
I mean,
can
yeah.
slow down and one at a time.
So tell the judge whether you think now this was self-defense or whether this was illegal.
I know now it is illegal, but at the time it was self-defense.
All right, so then the question is, do you take responsibility and do you acknowledge the guilt for the aggravated assault with a
Yes,
deadly
sir,
weapon?
I do.
Hold on. Aggravated assault with a deadly weapon case. Do you acknowledge your guilt?
Yes, sir.
And what are you asking the judge to do today?
If I would please get probation. It's my first offense. I simply was scared for my life, trying to defend myself.
And tell the court, why should the judge put you on probation?
Like I said, I know now if this would never happen again.
First off, right?
Right.
Do you have a criminal history?
No, sir, I don't.
Maybe a very limited one from Hidalgo County, like a harassment or something that's on the PSI?
None of that.
All right, everyone, one at a time. Okay, go for it.
Okay, and if you're granted probation, do you know that there's terms and conditions that come along with it?
Yes, sir, I do.
Are you going to follow all those terms and
I'm
conditions?
willing to comply all the way.
Are you going to use drugs while you're on probation?
No, sir, I don't use drugs.
You don't have a history of drug
No,
use,
sir.
right?
This is where things get messy. Anette is visibly conflicted. On one hand, she acknowledges guilt. On the other, she keeps circling back to self-defense. Legally, that's problematic. It shows the judge that she may not fully accept responsibility. And in sentencing, remorse and clarity matter. Did she minimize her guilt or just struggle with the trauma of that night? Either way, that dual acknowledgement raises red flags. Let us know in the comments. Do you believe her remorse is real, or is she playing both sides?
Are you going to work?
Yes, sir.
And the
Working.
PSI says that you're a caregiver, right?
Yes, sir.
Are you able to go back to some kind of job like that?
Yes.
Now, what if the judge says you're not able to work as a home care provider or anything like that? Are you able to find other kind of employment?
Yes, whatever is suitable for me.
Where would you go live?
My parents at the time being.
And do they live in close proximity to Miss Hernandez, Miss Tracy Hernandez?
No.
If the court orders you to stay away from the complainant in the case, would you stay away from her or would you go back to the Goodwill? And
No, I have no business anymore.
is there anything else that you'd like to tell the court before we stop?
Just that I'm truly deeply sorry, and I know now that all I was trying to do was defend myself. It was simply self-defense. I'm a mother of 5 kids and I'd like to go back to see my kids. I didn't see them for Christmas, Thanksgiving, or New Year's.
Thank you, Your Honor.
All right, any questions? All right, I do. The police report says that you were chasing her with a knife,
No, ma'am.
and they say that there's a video of you chasing her with a knife.
No, ma'am, I did not chase her with a knife. I was simply scared running because there was 2 women after me. Not only 1, 2.
All right,
Well, Judge, I don't know really what to make of this because lots of times we can say, well, the person has a mental illness, health, issues. They're on drugs. I don't know really what to make of this other than it's a one-time kind of incident thing.
where's the video?
It's in the discovery.
Any objection to the court seeing the video? Just, if you all have it, if I could see the video?
Takes a bit of time.
Sure. Because she's saying self-defense, and I'm being told that there's a video that shows something.
Annette's request for probation comes across as heartfelt. But here's the catch. She has no significant criminal history and is employed as a caregiver, which normally plays in her favor. But aggravated assault with a deadly weapon? That's a second-degree felony in Texas. Even with no priors, it's a hard sell. And when she says, this would never happen again, the judge has to ask, how certain can we be of that? Especially when the story she tells and the story on video might not match.
Differently.
Yes, Your Honor, but I think now she realizes it's definitely not self-defense. This is
Okay.
not a self-defense.
All right. So what I want to know is whether or not she was chasing somebody with a knife or not.
Probably I was scared, ma'am.
No, you said you were running from 2 women,
Yes, there were 2 women after me, ma'am.
but
And
the police report says that you were chasing the complainant with a knife. So Were you chasing a complainant with a knife or no?
Yes, to defend myself and run from, there was two women to defend.
If somebody's running away from you and you're chasing them with a knife, how are you defending yourself?
No, there were two women and one of them were after me.
Okay. All right. Well, we'll see the video, see what the video shows. All right.
I just saw the video, and so happens about halfway through.
Okay.
Roughly, but it's kind of slow.
Okay. Let's pause it and I'll let you offer it into evidence.
Judge, and just to protect the record, if I could, I'm just gonna say because the court's requesting it, because since they're silent, so it doesn't look like they're
Sure.
not.
All right. We're going to go back on the record and cause number 2023 CR 7274, State of Texas versus Anette Idago. The court had requested a video and for the state.
Daniel Escobar for the state of Texas.
All right. And defense, this video was actually mentioned in the stipulations to the court. Defense, are you offering the video?
Yes, Your Honor.
All right. And so this will be marked as defense exhibit number 1.
And here it is, the turning point. The judge reviews the surveillance video mentioned in the police report. Anette says she was running from two women, but if the footage shows her chasing someone with a knife, that flips her entire defense. Remember, video evidence often speaks louder than testimony. If it contradicts her self-defense claim, that could crush her credibility. And when she hesitates to identify herself in the video, the courtroom tension spikes. What would you do if a video called your entire testimony into question?
And the court will view the video. And I'm being told that the incident occurs at the halfway mark.
Well,
All right. Counsel, any objection to the court fast forwarding?
No, Your Honor.
And who is your client, counsel?
Believe the lady with the hat. Okay.
Let me pause it. Ms. Idago,
Yes, ma'am.
what are you wearing in this video?
No,
Are you the person in the black shorts?
ma'am.
Are you the person with the burgundy top with the blondish hair?
No, ma'am.
Are you the person in the gray shirt with blue jeans with the white hat?
I think so, yes.
And who is the person next to you?
The other lady, there were two ladies who approached me. I'm not sure. No, it wasn't. It was
Okay.
something else.
So are you saying you're the person with the white hat with the check and the gray top and blue jeans with the white shoes?
I believe so, Your Honor. Not sure. I can't really see. Mm.
Springfield start becoming like a scuffle.
Okay.
Not a melee. So no.
I'll make sure you speak up because
Oh,
the court reporter, we're still on the record. Okay, let me, just 1 second.
Say she's swung it.
All right.
This moment is telling. The judge pauses the video, asking direct questions about who's who. Annette stumbles, uncertain about her own appearance. That hesitation, it doesn't help her case. When your defense hinges on self-defense, clarity is everything. If you can't definitively say, yes, that's me, how can a judge believe your version of events? And the video doesn't lie. Body language, pursuit patterns, the weapon, it all gets analyzed. The court's patience is wearing thin.
All right. Any questions from the state? Yes. All right, defense?
Just a real brief argument, Your Honor.
Okay.
What we're asking you to grant Ms. Idago's application for deferred adjudication. You saw the video, Your Honor. In her mind, it was self-defense. I certainly understand the chase and all that kind of stuff. And she now understands how it is not self-defense. Nonetheless, Judge, she definitely takes responsibility for her actions. She's asking to be supervised by the court. I think she would benefit from some anger management and classes that help her deal with these kinds of situations and how to get herself out of these kinds of situations. So the long story short is, Your Honor, based upon her limited criminal history, her lack of drug use, the fact that she takes responsibility, we ask that you grant the application. Thank you.
Anything else you wish to say? Ms. Idago?
I just ask that God may touch your heart and understand that, like all I was asking is that if the Lord could hear me right now, he'd understand how much I repent of what happened that day. But it simply is just a self-defense in my mind, even though I know it's wrong.
Okay.
Thank you, Your Honor.
All right. Thank you so much.
Annette makes a final emotional appeal. She asks the judge to touch your heart, invoking her faith and family. It's raw, it's sincere, but emotions don't override facts. Her continued insistence that it was self-defense, even after acknowledging it's illegal, creates a contradiction the court can't ignore. The judge has to weigh sympathy against responsibility. Do you think her plea should have moved the court more, or did it fall flat against the evidence?
All right. So this is what the court is going to do. The court has heard all the evidence, and I want you to know that I internalize everything and I look at cases on an individual basis. The court is going to deny your application. Court will find you guilty. Court will sentence you to 3 years in the prison, give you credit for any time served. Take in consideration NIMAC number 714465, NIMAC number 723973. There's an affirmative finding of a deadly weapon. Is there anything else with regards to sentencing?
No, Your Honor.
I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Counsel.
I gotta walk around.
Thank you. Did you review that with your attorney? Did you understand it and did you sign it?
Yes.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, good luck to you.
Maybe excuse, Your Honor.
Yes.
Thank you.
And the verdict is in. The judge denies probation, finds Annette guilty, and sentences her to 3 years in prison. The deadly weapon enhancement seals it. Probation was never likely. This case is a textbook example of how powerful courtroom evidence, especially video, can overrule even the most heartfelt testimony. A first-time offender, a mother of 5, now faces years behind bars, not because the judge was cold, but because the facts left no wiggle room. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.